What are Articles of Incorporation? When incorporating a new company, one needs to make reference to the specific statutes and laws of the particular jurisdiction, whether it's a country, state, or province, within which that corporation is to be formed, and look to its corporate registrar with respect to the particular documentation that must be prepared and submitted to the corporate registrar to effectuate the incorporation of the new company. A primary incorporation form that must be completed and submitted to the corporate registrar are the provisions that are to form part of the company's Articles of Incorporation. Once the form is completed and processed by the jurisdiction's corporate registrar, the corporate registrar will issue, together with the Certificate of Incorporation and other incorporation documents, the Articles of Incorporation that will set forth certain of the key attributes of the corporation as you had previously determined. Among the attributes that the corporate registrar will typically require to be specified in the Articles of Incorporation would be the number of directors that the corporation is permitted to have, which can include a permissible range specifying minimum and maximum, the number and classes of shares, the specific attributes of particular share classes, any restrictions as to the issuance, transfer, or ownership of shares, any restrictions or requirements that the corporation might have with conducting its business, and any further rules or provisions ascribed to the corporation. The Articles of Incorporation will also set out the name of the corporation, the name of the incorporator or registrant, and in the case of a federal corporation, the province or territory of its registered office. As such, the Articles of Incorporation serves to establish certain key parameters as to the corporation's ownership and operations, which can vary from company to company based upon what you seek to include or exclude from the Articles of Incorporation and how those attributes are specifically written up for the articles. A company's Articles of Incorporation can be very basic and lacking in complexity, with only the minimal amount of specificity in the depiction of those attributes. On the flip side, some Articles of Incorporation can be exceedingly complex, being very extensive depictions of these corporate attributes, as is a tendency with lawyers who develop or rely upon extensive write-ups as to share attributes, corporate restrictions, and the further rules and provisions for the corporation. The Articles of Incorporation therefore sets forth key attributes of the corporation that the jurisdiction's governing authority has determined must be set forth and made part of the government's record, such that it cannot be changed without receiving the requisite authorization to amend the Articles of Incorporation, so as to bring it into conformity with the jurisdiction's Business Corporations Act. This provides for a heightened level of control and protection to the corporation's shareholders. Thank you.